Present in the virtual courtroom, we have both parties along with Attorney Jordan Swears representing the plaintiff, Ms. Huey. This is the date and time scheduled for a trial in this matter. And Mr. Swears, would you call, well, first of all, do you wish to make an opening statement or do you want to waive your opening statement?
No, we'll waive and rely on our trial brief, Your Honor.
Okay. And Mr. Huey, I know you're representing yourself. The court has to hold you to the same standards as an attorney, which means all of the rules of evidence, all of the court rules, all the case law, all of the things that people learn in law school. So you are entitled to represent yourself. I'm just kind of giving you a heads up and a warning that I will be holding you to those same standards because that's what I'm required to do. So an opening statement is when each side gets the opportunity to tell the court what they believe the proofs, the evidence is going to show in their case. And Mr. Swears, probably in the interest of time, is waiting his opening statement. So do you wish to make an opening statement or do you wish to just get going?
We should address everything as it comes along, right? Is that my understanding?
Right. Yeah. An opening statement is just a summary, but you think the evidence will show, but you know, and you can make one.
No, we can just continue if that's okay.
All right, then that's fine. The record should reflect that Mr. Huey has waived his opening statement. All right, Mr. Swears.
Your Honor, again, just to get them out of the way, I'd like to move for admission of our proposed Exhibit A. It is a demonstrative. It's simply the asset schedule requested by the court.
All right. Mr. Huey, just so that you know, a demonstrative exhibit is not accepted by the court as proof of the items on it. It's simply a document that can be worked off of by all parties. This kind of summarizes what the plaintiff is claiming, but it is not actual evidence in the case, if that makes sense. So do you have any objection to that?
No.
Okay. All right. Then it's admitted for demonstrative purposes only.
And then I'd also like to move for the admission of our Exhibit I. This is the State Bar of Michigan 2023 Economics of Law Report, and we would move for admission as self-authenticating under MRE 9025.
Any objection to that, Mr. Huey?
I don't really understand what it means, but no.
Okay. It's a statement that the State Bar has put out that indicates what attorney fees are around the state, etc. The State Bar has published it, and frankly, the court could probably take judicial notice of it, but it's a reliable piece of evidence, so I will admit it.
All right. Thank you, Your Honor. We would like to call our first witness, Julie Lemon, who I believe is in the waiting room.
All right. Ms. Van Uller, would you bring her in from the waiting room?
And are you related to any of the parties in this case?
Yes, Deborah is my daughter.
All right. I'm going to start with some questions just about some of the property in this case. Does Deborah own a car?
Yes.
What kind of car does she own?
2013 Ford Escape.
Do you remember when she bought the vehicle?
November 2023. I don't have an exact date.
November is close enough.
Okay.
When she bought the car, was it a new or used vehicle?
Used.
Do you remember about how much she paid for the vehicle?
It was a little over 12,000 plus tax and fees and all of that good stuff.
Now, at the time that Tom and Deborah bought that vehicle, did they have enough money cash on hand or did they need a loan for purchase of the vehicle?
I paid for the vehicle.
All right, so you paid directly for the vehicle?
Correct. To Cool Chevrolet.
Right. Now, so did you pay for it because they didn't have the money for it, or did
Correct.
You
they did not have the money and they needed a reliable vehicle to transport the children.
Now, at that time, did you have an agreement with Tom and Deborah regarding whether they were supposed to pay that money back?
Yes. I mean, yeah, it was a loan. It was to be paid back.
And as we sit here in court today, has that loan been repaid?
No.
All right. I'm going to move on. Does Tom own a car?
Yes.
Do you know what kind of car Tom has?
It's, I believe, a 2005 Mercury Milan.
Mercury Milan?
Yes.
Right. Do you remember about when he bought that vehicle?
It was also November.
All right. Now, prior to purchasing the Milan, was there a time period where Tom needed a rental vehicle?
Yes. In September of 2023, they were using one of our vehicles, one of me and my husband's vehicles, 2012 Chevy Equinox, and Tom hit a deer and totaled it. So while they were working on that to see if that car could be fixed or whatnot, they rented a car.
All right, and Your Honor, I'm not certain. Does Tyler prefer to show the exhibits directly or to have us do a share screen?
I think it's whatever is easier. If you can do it, that'd be great.
I will attempt that, Your Honor. I'm usually able to pull that off. Well, all right, so this is what
Is there, sorry, is there a way to enlarge it? It's really small on my screen, at least. Much better. Thank you.
All right, so Julie, I'm showing you what has been marked as plaintiff's proposed Exhibit E. Have you seen this before?
Yes. Yep.
Can you tell me what it is?
This is the rental car for when they were using from the car accident, where it references like State Farm, because that's my insurance.
Because I'd like to get it admitted first. Does this receipt look to be the same as the last time you saw it?
Yes.
Your Honor, I'd move for admission of proposed Exhibit E.
Mr. Huey, any objection?
The whole story is.
Well, no, that's not,
fabricated.
this isn't your opportunity to make a statement. It's just a question of whether or not you object to this exhibit.
Yes, I do.
Based on what? Again, this is where the rules of evidence come in.
The renter was because I was the only one that had a license when we were at
Again,
the
this isn't your opportunity to explain anything.
Okay,
You'll have the
I-
opportunity to cross-examine. It's really whether under the rules of evidence, this exhibit is admissible. In other words, that it is what it purports to be.
It is what it reports to be then, ma'am.
Okay, then it's admitted. Thank you.
Thank you, Your Honor. All right, Julie, so I want to, off on the left-hand side here, do you see where it says renter?
Yes.
Can you tell, so who is the renter in this case?
Thomas Huey.
Now, at the bottom, there's a MasterCard number. Is that Tom's MasterCard?
Yes, it is.
All right, so Tom paid directly for this.
Yes, he did.
Can you explain to the court why, or what the context is where there's a loan, since this is obviously showing a payment at that time?
Okay. So to rent a car, you have to go in, with a debit card, credit card, whatever, and a driver's license. Tom was the one that had the debit card in his name prior to going to the rental company. I went with Tom to Fifth Third Bank and we transferred money from my account to his account to pay for this rental so that they could use their debit card and pay for it.
All right. So like the Ford Escape, was there any discussion? Was this a loan or was this just a gift of a rental car after he hit the deal with yours?
Well, it's a loan. And that was very clear in conversations with both of them.
All right, let's go back to the Mercury Milan then that he bought after this. Do you know who he bought the Mercury Milan from?
The car was purchased from my sister, Michelle DeWitt. She
All right, and did sorry,
sorry.
I'll just keep moving along here in the interest of time.
Okay.
Do you know how much they paid at that time?
I paid her $500 for the vehicle. I paid her so that they could go pick it up.
So again, was that because you were giving them the car? They didn't have the money? What was
They
the
did not have the money.
Was that also a loan you expected to have repaid?
Yes, and it was very clear that the car should have been titled in Deb's name.
All right, and again, can you remind the court when that was purchased?
November sometime.
All right, so basically right before the divorce was initiated.
Up.
All right, thank you, Your Honor. I have no further questions for this witness.
All right, Mr. Huey, if you would unmute. If you were represented by an attorney, your attorney would be able to cross-examine Ms. Lemon, since you're representing yourself. You may do this. However, you can, which means you can ask her questions about the testimony that she just gave. But it is not a time for you to argue with her. I'll give you a chance to tell your start side of the story at some point. But this is not that time. Simply just ask her questions about the testimony that she just gave. Okay.
Yes, ma'am.
Okay. So go ahead whenever you're ready.
Okay. I don't know if it will help on asking on cross-examination, only because they have I just don't want to argue. So
I'm sorry. I
I'm
didn't
not
get
sure. I'm not sure if my line of questioning would actually benefit this or just hinder it.
Okay, it's up to you, but if you need her to clarify something she said, this is the time to do that, because once she's done testifying, you won't be able to recall her.
Oh, okay. No, it's just it's gonna turn into I don't know the proper way to present the question, so we would just pass it because it's just gonna be a battle, and I'm not trying to waste the court's time.
All right, so you're waiving cross-examination?
Yes, ma'am. In the thoughts of not and not making myself look like a fool.
Okay, well, like I said, I mean, this is your one and only chance to ask her questions. I wouldn't worry about making yourself look like a fool, because I'm sure Mr. Swears will object and I will address it. But you certainly can ask her questions if you'd like. I just want to make sure that you're waiving that knowingly.
With my best thought, I think that would be because the only way I could would make a statement, ma'am. So I don't.
Okay, all right.
Thank you.
That's fine then. Mr. Swears, well, first of all, may Ms. Lemon be excused?
Yes, Your Honor.
Mr. Huey, any objection to her being excused?
No, ma'am.
All right, Ms. Lemon, you may leave. Okay, Mr. Swears, next witness. Yes.
Your Honor, at this time, I would call Deborah Huey,
All right, and I'm going to need her close to the microphone.
and you are the plaintiff in this case.
Yes.
All right, Deborah, I'm going to start by asking just a couple of administrative questions to cover the proofs that the court will need to take to enter a judgment. If at any point you can't understand or hear me, just stop me and I'll repeat the question. Did you file a complaint for divorce in this case on or about December 4th, 2023?
Yes.
Were you and Tom separated at that time?
Yes.
At that time, had you lived in Kent County for at least 10 days?
Yes.
Had you lived in the state of Michigan for at least 180 days?
Yes.
Were the allegations in the complaint true at the time the complaint was filed?
Yes.
Are those allegations still true today?
Yes.
Are you currently pregnant?
No.
Has there been a breakdown of the marriage relationship such that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
Yes.
All right, Deborah, I'm going to shift on and let's talk briefly about the marital assets and liabilities. I'm just going to steal my mouse here for some exhibits. I'll start by talking about your car. What kind of vehicle do you drive?
A Ford Escape, a 2013.
And just for the record, if you could identify what exhibit you're referring to. Again, this does get turned into a transcript, so it's important to identify.
All right, and apologies, I had left the previous exhibit E up, Your Honor, but we're not going on that one.
So which exhibit are we looking at?
At the moment, none, Your Honor. We'll be at exhibit C.
All right, okay.
All right, so Deborah, you heard your mother testify about a loan to purchase that vehicle. Was it also your understanding that that was money you needed to and still need to repay for your Ford Escape?
Yes.
All right. And obviously, after the court enters a divorce, it might be a bit awkward for an ongoing financial relationship between your family and Tom. So is it your preference that you be responsible for making those payments and satisfying that loan?
Yes.
All right. Is the Ford Escape still the vehicle that you're driving?
Yes.
All right. And you believe you should keep the vehicle following the divorce?
Yes.
All right. I'm now going to pull up what has been plaintiff's proposed exhibit C as in Charlie. All right, Deborah, do you recognize this proposed exhibit?
Yes, I do.
Can you tell the court what it is?
It's the Kelly Blue Book value of my vehicle, the Ford Escape.
All right, and that's your vehicle by the Ford Escape and the VIN number up top?
Yes.
And then at the bottom here, I recognize this is a computer screen snapshot rather than a printout, so it's a little rough. Do you see where it has values there?
Yes, I do.
And does this screenshot look to be in the same condition as the last time you had seen it?
Yes.
Your Honor, I'd move for admission of proposed exhibit C.
Any objection, Mr. Huey?
No.
All right, it's admitted.
All right. So, Deborah, On the bottom left, there's a green box that says private party range, and below that, an average value. Can you see what that value is?
Yes,
Can you read that value for the court?
the private party value is $7,666.
All right. I'm going to go ahead and take that exhibit down. All right. And then your mother also testified that she transferred money as a loan for a rental vehicle in September 2023. Do you believe you should also be responsible for satisfying that loan after the divorce?
Yes.
All right. Your mother covered some of this, but I'm just going to recover it just for clarity. What kind of car does Tom have?
Mercury Milan.
Do you remember about what year that Mercury Milan is?
I believe it's 2010.
2010.
Ma'am, can you speak up just a tiny bit?
Oh, yes. I believe it's a 2010.
Much better. Thank you.
And at the time Tom bought that vehicle, did you and Tom have the cash on hand, or did you also need a loan from family?
We also needed a loan. We did not have the money.
Can you tell the court why you got the money from family instead of going to a bank or applying for a car loan?
Felt it was easier and quicker, and we had kids, or we had, both the boys. It was much quicker than waiting at a bank or a car dealership to do the paperwork.
All right, I'm going to show you what has been submitted as proposed Exhibit B, as in Bravo. And I'll zoom in. Do you recognize this?
Yes, I do.
And can you tell the court what it is?
It's the Kelly Blue Book for the Mercury Milan.
And does it appear to be in the same condition as the last time you saw this screenshot?
Yes.
Your Honor, I move for admission of Exhibit
Any
B.
objection, Mr. Huey?
No, ma'am.
All right, it's admitted.
All right, and at the bottom left again, do you see the private party range?
Yes.
Can you tell the court what the private party value there is, the average?
I believe it says $3,832.
All right. I'm going to shift briefly over to some prior housing. Did you and Tom ever live at one
Yes, in Rockford.
in Rockford? All right. Did you own or did you rent that property?
We rented.
Can you briefly describe the house for the court? Number of bedrooms, bathrooms, just like the one-liner Zillow rental summary.
It has technically 2 bathrooms, but we only used one. And they advertised it as a 3-bedroom, but it was more of a 2-bedroom.
Do you remember about what your monthly rent was?
$1,800.
Was there ever a time in 2023 when you and Tom did not have the money to pay the rent?
Yes.
Did anyone else pay the rent for you?
Yes, my grandmother.
What's your grandmother's name?
Carol DeWitt.
All right, I'm going to show you what has been proposed as Exhibit D, as in Delta. Can you tell the court what these are?
Those are the checks that my grandmother paid for our rent.
All right, and do they appear to be whole, complete, and intact copies of the check receipts?
Yes.
Your Honor, I move for admission of proposed Exhibit D.
Any objection, Mr. Huey?
Yes.
Okay, what's the basis of your objection?
These are stubs. We gave her grandmother the money to write it, so we didn't because we didn't have time to get the money orders.
Okay, again, this isn't the time for you to tell your
So
side.
no, but that was the reason why I was objecting.
Okay, no, the basis for objecting would be, you don't believe that it's an accurate representation of what it says it is. You believe it's fraudulent, something like that, but you can give your explanation later when it's your turn, okay? All right, it's admitted.
Thank you, Your Honor. All right, so can you tell me, these checks are made out to Kelly Wood? Who is Kelly Wood?
She was our landlord.
All right, the bottom one, that was your address?
Correct.
Now, the top one here says it's from mid-month, September 10th, 2023. Can you tell me why there's a mid-month check?
Because the rent was late.
All right, so you were already overdue at that point?
Yes.
And then the second check, that's dated October 1st. What month's rent was that for?
October.
To the best of your memory and recollection, have you and Tom ever paid your grandmother back for these 2 rental payments?
No.
To the best of your knowledge, was it your agreement with her that she would be paid back at some point?
Yes.
And like with the cars, do you believe that you, rather than Tom, should ultimately be responsible for this after the divorce?
Yes.
For making the actual payments?
Yes.
All right, I will pull this exhibit down. And let's shift over to school tuition. Did Michael ever attend St. Peter's Lutheran Preschool?
Yes, he did.
And where is St. Peter's Preschool?
It's in Rockford. It was just down the street from where we were living.
Yeah, so walking distance or?
Yes.
Did you and Tom always pay tuition yourselves, or did someone loan you the money for tuition?
My grandmother loaned us the money.
Do you remember how much that tuition was?
It was just over $2,400.
Got it. Was that also a loan that the agreement was to pay back at some point?
Yes, it was.
And that still needs to be paid back?
Correct.
All right, so you've identified 6 specific personal or family loans you believe should be included in the marital estate. So I just want to confirm those. There's the $1,800 to your grandmother, Carol DeWitt, for the September 10th payment.
Yes.
There's an $1,800 again to Carol DeWitt for the October 1st payment. Is that correct?
Yes.
All right, $2,415 to Carol DeWitt for tuition at St. Peter's School.
Yes.
$500 to Julie Lemon for the Mercury Milan,
Yes.
and $463 in change for the rental vehicle.
Yes.
Now, we briefly talked about this as it related to the one car, but these are all personal loans, not bank loans. Can you just explain to the court why you took these as personal loans rather than going to a bank or financial institution?
My family had the money. It was easier to talk to them and to repay it when we could repay it than versus a loan that we had to make set payments on when we were already having a hard time.
And so during your marriage to Tom, was it normal practice for you to take loans from friends and family rather than a bank?
Yes.
Now, you've submitted a proposed distribution of assets to the court that was admitted as Exhibit A. Do you believe that exhibit is a fair and equitable division of the marital estate?
Yes.
All right, Deborah, I'm going to move away from property and briefly talk about child support. Now, this court previously entered a temporary support order. The calculations for that order were based on your last job before the order was entered. Can you remind the court what your last job was?
I was a caregiver through the state of Michigan for my sister.
And I'm sorry to ask this, but can you tell the court why you stopped working as the in-home caregiver?
My sister passed away
And when did Chelsea pass away?
June 29th.
Since that time, have you started with a new employer?
Yes.
What is your current position?
I'm a paraprofessional at Zinzer Elementary School.
What's your hourly rate of pay?
$15.46.
And about how many hours are you currently working per week?
15.
Does that position
Can you
work
give me- I'm
around?
sorry, can you give me that hourly rate again?
$15.46.
46. Thank you. I didn't write it down quick enough. Thank you.
Does that position work around Michael's school schedule? So do you need to basically, let me rephrase. With that position, do you have to pay for childcare or are you able to provide childcare directly?
I am able to provide childcare directly
Now, is that position at the school year round or just during the school year?
during the school year.
So if I do my math correctly, the 15 hours, 1546 for school years, I think 36 weeks, that's slightly less than the amount the previous calculation used. Is that correct?
Yes, that's correct.
But you're asking the court to keep the imputation from the last order. Is that correct?
Correct.
All right. To your knowledge, has there been any change in Tom's employment since the order was entered?
Not that I'm aware of.
All right. So I'm going to shift over and let's talk parenting time conditions. The last thing I want to ask you about, we'll start with the easy one. The current parenting time order has you picking up Michael at the Sparta police station. Is that where you've been picking Michael up?
Generally, yes.
And the current order has Tom picking Michael up for his parenting time at the Walker police station. Is that where you've been dropping Michael off?
Yes.
Which of those locations is closer to your home?
The Walker Police Station.
Would picking Michael up at Walker instead of Sparta make it easier to get Michael to bed on time?
Yes, it would.
And just to be clear, you're asking to switch these locations so there won't be any overall change in drive time. Is that correct?
Correct.
All right, let's talk about the exchanges themselves. All right, I'm going to pull up what has been proposed as Exhibit F. Apologies, Your Honor. It might mute my microphone when I'm sharing the audio, so I'll try and go back and forth if it's flashing a little bit. So Deborah, what I'm going to do is I'm going to share this proposed exhibit with the court, and then I'm going to play about the first 5 to 10 seconds and ask you some questions to identify and authenticate the exhibit.
Okay.
That's my work car. Take pictures of it, dog. Here I am, you fat piece of shit. Hi, bud. It's at 8 p.m.
All right, Deborah, do you recognize this video?
Yes.
All right. Can you tell the court where is this video taken?
Sparta Police Station.
How do you recognize this location?
That is where we do our exchanges.
Can you tell the court, do you recognize who the person in the orange tank top was?
That was the defendant, Tom Huey.
Were you present at the time this video was taken?
Yes.
Do you know who took this video?
My stepdad, Doug Lemon.
And he was present for the exchange as a third party?
Yes.
Can you tell the court what day this took place?
August 11th.
All right. Deborah, I'm going to reshare this and play the entire video. It should take about 4 minutes.
Can we identify the year?
Oh, yes. Can you identify August 11th of what year?
2024.
Thank
And
you.
Your Honor, before I play the rest of it, I'd like to move for admission of proposed Exhibit F.
Any objection, Mr. Huey?
No, all the videos that he wants to show they're true. So I don't know if we need to waste our time, but I
Okay.
understand.
Well, in that case, if on admissibility, Your Honor, I'll move for admission of Exhibit G and F while we're at it and save us a few minutes.
All right. It sounds like you stipulated to those. Thank you.
Thank you, Your Honor. All right. So, Deborah, I'm going to play this and then I'll ask you a few questions.
Okay.
It's my work car. Take pictures of it, dog. Here I am, you fat. Hi, bud. It's at 8 p.m., not 5 p.m. You can go all you want, you big piece of sheep. You guys are rude and you're disgusting. Put me on tape. I got first shit of you guys. Ooh, I said shit. Give me a hug, Mike. I'm your dad. They don't get to act this way, like, all the time. I love you, man. All right, Mom. I miss you, too. Hey, Mommy will probably drown you in a bathtub. When she kills him, get this on camera. When she kills him, I'm taking her to the grave with me. Call the police. Dude, I'll stay here till 8. You lousy piece of shit.
Woo! Good job! You're so big!
Oh, you got it recording? Next time you threaten me with a gun, Doug, put the gun down and just hit me with your fist. Love you, baby. Huey for life. Come on, Doug, do something, dude. Right in front of the police station. Come on. You, Julie. Wow, your daughter's dead. Good for you. You probably killed her. Or Deborah did.
All right, Deborah, I'm going to ask you a couple of questions about that video. So at about 3 seconds in, Tom says, "Here I am, you fat piece of shit." Do you know who he's referring to there?
I believe myself.
Around 33 seconds in, while he's talking to Michael by his car, Tom says, "Mommy will probably drown you in a bathtub. When she kills him," this being directed towards the vehicle, "get this on camera. When she kills him, I'm taking her to the grave with me." When Tom says she kills him, do you understand that to be a reference to you killing your son?
Yes.
And that was said right in front of Michael.
Yes.
His reference then to taking her, and I'm using air quotes there for transcript, her to the grave, is that also a reference to you?
Yes.
Around 2 minutes and 30 seconds, Tom says something about someone, quote unquote, threatening him with a gun. Did anyone threaten Tom with a gun?
No.
To be clear, this exchange is in the parking lot of the Sparta Police Department. Is that correct?
Yes.
At 2 minutes and 54 seconds, Tom says, "Julie, your daughter is dead." Is that a reference to your sister, Chelsea?
Yes, it is.
And when he says you probably killed her or Deborah did, again, a reference to Chelsea?
Yes.
And you testified Chelsea had passed away at the end of June. So that was only about 5 or 6 weeks before this, right?
Yes.
At the end of the video for the last 30 seconds or so, you can hear someone crying in the background. Can you tell the court who is that crying in the background?
My son, Michael.
All right, I'm going to switch over and show Exhibit G. This one's significantly shorter.
buddy. I can't go away. I got it. Look, I
We're making a movie. Hi. We're making a movie. This is the guy right here that has a gun and is trying to kill me.
All right, just for clarity on timeline, this is the August 14th video that was admitted by stipulation. Whose Mercury Milan is that?
That is Tom's.
And about 47 seconds in, was that Michael coming over to your car?
Yes.
So at about 1:13, there's a window that rolls down on Tom's car. Is Michael already in your car at this point?
Yes.
So the parenting time exchange is, for all intents and purposes, complete.
Correct.
All right, so then Tom rolls his window down, backs up and holds something up to the window, looks like a phone, and says, "Hi, we're making a movie. This is the guy right here that has a gun and is trying to kill me." That's all after the exchange is completed.
Yes.
Was anyone at this exchange trying to kill Tom with a gun?
No.
And this is the same parking lot at the police department in Sparta, correct?
Correct.
All right, I'm going to show you the last video. This is Exhibit H. This is the September 8th parenting time exchange. And same thing, I'm going to mute and let the video play.
Bye. You know you're a child and you keep traumatizing my child?
You're the one-
You already killed one of yours. You don't need to traumatize mine. The PPO is coming though. Bye, bitch.
All right, so at about 23 seconds in, was that again Michael running to your car?
Yes.
So for all intents and purposes, the exchange is complete by 30 seconds into this video.
Correct.
All right, so then Tom backs the car up all the way up by your car, rolls his window down and says, "Bye, you know you're a child. You keep traumatizing my child. You already killed one of yours. You don't need to traumatize mine. The PPO is coming though. Bye, bitch." The reference to a dead child, is Tom talking to your mother here?
Yes.
But again, by the time he backed up, Michael was already in your car.
Yes.
And the reference to killing someone, you understand that to be a reference to Chelsea?
Yes.
So based on Tom's statements and actions at past parenting time exchanges, and this is over the last 6 weeks, do you believe exchanges should continue to happen at the police stations?
Yes.
Do you believe Tom will continue to act aggressively unless the court imposes parenting time conditions to govern his behavior?
Yes.
But at this time, you're not trying to change anything. You still want Michael to have a relationship with Tom.
Yes.
All right, I'm going to shift very briefly to spousal support. As I noted for the court earlier, we hadn't actually agreed on a resolution, but just to be clear, you are not seeking an order for spousal support. Is that correct?
Correct.
Thank you, Your Honor. I have no further questions for this witness.
Mr. Huey, do you wish to cross-examine Mrs. Huey?
No.
All right. And again, you understand this is your only opportunity to do so.
Yes, ma'am. I wish to exchange 0 words with her.
Okay, thank you. Any further witnesses, Mr. Swears?
No, Your Honor. Plaintiff rests.
All right. Okay, Mr. Huey, now the case transfers over to you. Any witnesses that you would like to call?
No, ma'am. I don't have any witnesses.
All right. Do you wish to call yourself?
If I can recount events because these are
All
very
right, hold on,
jaded
hold
and
on,
it's
hold
very
on. If
one-sided,
you're gonna,
but-
hold on, if you're gonna
I'm
testify.
sorry, ma'am. I'm not trying to.
I know, it's okay.
Okay. Okay.
I need to
Sorry.
swear you in though before you can start talking, all right? Would you raise your right hand? State your name for the record.
Thomas Edward Huey Jr.
Do you swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
All right. Now, if you did, you can put your hand down. If you had an attorney, your attorney would be questioning you much in the same way Mr. Swears was just questioning Mrs. Huey, right? But Mr. Swears, are you willing to permit him to testify in the narrative?
Yes, Your Honor.
All that means is you don't have to ask yourself questions and then answer questions. You can just talk. Okay, but
Okay.
So go ahead whenever you're ready and try not to start going too fast. People when they're nervous tend to speak quickly. So it's important that I understand what you say. Okay.
Yes, ma'am.
Okay, go ahead.
So the basis for our separation is the treatment that the plaintiff put upon my 6-year-old at the time.
Objection as to relevance.
The
I think
relevance
you
is,
can, hold, sir, wait,
oh,
when there's an
sorry,
objection, you need to wait for me to roll. Okay.
okay, sorry, ma'am.
I will allow the testimony.
Thank you, Your Honor.
Go ahead, sir.
Okay. The reason for that was the mistreatment of my older child that we do not share together. I made the executive decision to send him to go stay with his mother. I have maintained a 50-50 his whole life. We have stayed out of the court systems, so we have a really good relationship. I filed a motion for, I want to recall, I don't remember the full name of it, but it wasn't an ex parte, but I filed it the day after the plaintiff filed for divorce. And in her divorce, she was seeking full custody, full everything. After I filed my motion, she sought legal counsel and filed the ex parte. So when that happened, my motion was, I guess, not relevant anymore. So then her motion took place, and then we had to attend mediation, which got me closer to parenting time reestablished with my younger son. And then we attended another mediation, and it got me overnights. I moved to Crystal to have my own apartment because I was living in somebody else's residence. And then in August 1st, just 2 months after having the place in Crystal, I was able to get into Kent City, where I had one of the first places I had applied to in December of 2023. So to be closer to both of my children. My older son, he resides in Sparta, and my younger one resides in Grand Rapids. As far as for the rent, it was cashier's checks that we were supposed to use to pay her, or a check. And the bank account that we had just I think it was Fifth Third. I'm pretty sure it was a Fifth Third. It was right down the road. And we didn't have checks for them. So her grandma wrote us checks and we gave her the cash. The vehicle in question, that the plaintiff's vehicle, the basis of that was her grandfather passed away and her grandmother inherited the car. But instead of signing it to us, it was signed to her mother to avoid paying lengthy taxes on it, because it was a really nice car. It only had 80,000 on it in miles. I hit a deer. We were under the premise that if we did get in an accident or anything else or a ticket, we would tell the cops and everything else that we were just borrowing the car. So when that accident occurred, her mother got an insurance check for that. Well, her mother and grandmother felt obligated to get the plaintiff another car. So between the mother and grandmother, they both came up with it and got her the Ford Escape. And the only reason why I was put on the title, which I was very confused on, I don't understand why I was put on the title. And so there is that. I did agree to pay the $500 for the Mercury Milan. So I am not denouncing that. Her mother did tell us we didn't have to pay it back, but I planned on paying it back. And then the divorce and all that happened. So it was sort of just up in the air. I'm sorry, I feel all over the place. The rental was used with my account, yes. And I think we did get a loan for the rental from her mother. But I was put on it because I had the bank account. Deborah did not have the bank account. And Deborah didn't have her license when we went to the car rental place. sorry, I got here. As far as the child support, I think that should be adjusted. Only because the basis of I only make $1,000 every 2 weeks, and with my bills and everything else, I don't have anybody to help me. But I do understand the importance of paying it, so I'm not trying to make an excuse on the reason why I can't pay it, even though that's exactly what that sounds like. I'm not sure where else to go, ma'am.
Okay. Any of the contested issues, that's what you need to talk about.
Okay. So the rent, I don't, that's not, I don't know. I feel is there something I missed? The videos of me at the exchanges are true. I have no excuse for them. I would like if her father has threatened me with a gun. He stopped me at a family fair parking lot and pulled it out. I went to go file in Walker on one of the days of exchange because I was just tired of the plaintiff and her mother recording me and harassing me upon pickup. And immediately after I came out, they went in, and then I never heard anything else from that. So, but they have been recording me at exchanges, at every exchange since December. I have never had anybody else in the car with me. 90% of the time I stay in the car. I just have my son get out. The past few times I have in August and the one in September, I did not maintain a composure that I should have. And I am aware of that. And I'm pretty sure that's about as far as I'm not sure.
Okay. Mr. Swears, any questions?
Briefly, Your Honor. So, Mr. Huey, you mentioned that you understand the importance of paying child support. Is that right?
Yes, sir.
Have you been paying child support?
Yes, I have made a payment, but I also have other debts that I need to pay, like a place to live, because if I don't have a place to live, then you guys will say that I don't deserve overnights and I will be homeless.
All right. So you're aware that you're currently $3,567.50 in arrears on child support?
Yes, and I don't agree with that either. I don't think that should have been retroactive for 6 months of somebody denying me my child time.
And by somebody denying you your child time, you mean the court denying it by court order. Is that correct?
By the plaintiff getting a lawyer and falsifying records. So yes.
All right. But you recall you also asked the court to set a parenting time schedule at the beginning of this case. Isn't that correct?
Yes. And then it was met with you sending me a threatening email.
We'll go on.
Okay.
Early December, you actually texted Deborah about parenting time, and you said you weren't comfortable working it out with her. You wanted to wait and just see what the judge says. Is that correct?
That was before she filed the ex parte.
Okay, so it was okay for you to file a motion to establish parenting time, but not for Deborah to do it.
When I put the truth in it, when you put lies in it with a lawyer.
Okay, I think we all understand the answer.
Yeah.
You just testified that we've attended 2 mediations. So the first mediation was with the Dispute Resolution Center in May. Is that correct?
Yes, sir.
When was the second mediation?
The second mediation was in June.
Who was that with?
That was through the court system too.
All right.
The
So you're
first
not
one was
referring
the
to,
first one was court ordered.
you're not referring to a second session with the Dispute Resolution Center. Is that correct?
I'm not exactly sure what their second one was through. I understood it was set up through the court.
All right. Do you recall requesting a second mediation with the Dispute Resolution Center in late August?
Yes, I did.
And you canceled that one, is that correct?
Yes.
All right, so we had the one Dispute Resolution Center in May, nothing in August, and you're not certain what this other...
We had 2 dispute resolutions, sir.
All right, was the second one you're thinking of the settlement conference with...
We
the
had
court?
2 different mediators. There were 2 different mediators. If one of them wasn't through the dispute resolution, you weren't there for one of them, sir.
Okay, you're talking the friend of the court investigated
Yes, sir.
conference.
That
Okay.
was the first one.
I'm caught up now.
So it would have been a third mediation that I denied.
All right, with regards to rent, you said there's some dispute as to the transfer of funds. I'm not going to spend the court's time on it. I want to finally ask you just briefly, you talked about the videos of the exchanges. You said you have no excuse for that action. You were aware you were being recorded. Is that correct?
I'm recorded every time, sir.
Right. And in fact, part of the point of having these exchanges at the police station is to avoid some of the issues that were present in December of last year. Is that correct?
Yes, sir. Yes, sir. If the plaintiff's parents didn't need to be there, none of this would make any sense. She's the one that gets out of the car.
Well, in the first video, was that not you walking across the parking lot towards Deborah's
No,
car?
I did not walk across the parking lot. I maintain a distance.
All right, but
Her
you still
father has
approached
threatened me with a
halfway
firearm.
across.
My life is
Okay.
important. Thank
I'm
you.
going to ask the question, and I just need you to ask the question, answer the question I'm asking, Mr. Huey. So you walked about halfway across that parking lot. Is that
No,
correct?
sir. No,
All right.
sir.
Well, the video speaks for itself. Do you think it's appropriate to refer to Deborah as a fat bitch in front of your son?
No, sir, but no.
Do you believe it's appropriate to tell your son directly that his mother is going to harm him by drowning him in a bathtub?
Yes, sir.
All right. So you believe that's appropriate to tell? How old's
Sir,
Michael
she
now?
told my
5
son
years?
fucking kill
Tom,
himself and she hated
Tom,
him. So you need
I'm
to
gonna ask the
represent yourself
question.
correctly.
All right,
sir.
you both, hold on. You both can't talk at the same time. The transcriptionist will kill me. You have to take turns, okay? Don't talk over each other. Mr. Huey, you do need to just answer Mr. Swear's question. I will give you the opportunity to explain, okay? Your answers
Understood.
after
I
he's done with
apologize.
his questioning. We have to
I
take
apologize.
turns.
Sorry,
There are
ma'am.
court rules that govern this. Okay, go ahead, Mr. Swears.
Thank you, Your Honor. Michael is 5 now. Is that correct?
Yes.
All right. So I think I'll ask kind of the open ended on the last 2, and then that should be all I have. On the last 2 videos, Michael goes to the vehicle about 30 seconds in, and then you seem to prolong the exchange to initiate some sort of confrontation. Can you explain to the court why you went just at that point? Again, if you're worried, like you said, about people or this exchange, once Michael's off to the other car, why you went just drive away?
Sir, you do realize I have another child, and when I exchange, he unbuckles. They spend time with each other because their time is limited. So I have to make sure he gets rebuckled. It's about safety.
Is your other child the one?
I don't hang
telling
out
you
for
to-
5 minutes. I don't hang out for that long.
Is your other child the one telling you to back the car up and roll the window down to engage with these people?
I'm not going to answer you, so no.
I have no further questions, Your Honor.
All right, Mr. Huey, this is your opportunity to explain the answers you just gave.
A lot of this is open-ended. A lot of it is to make sure Jordan Swears gets paid. That's his main objective. So a lot of this has been combatant. Part of wanting to get through this. I denied the last mediation because I wasn't gonna. He sent me 2 different emails trying to get me to agree to a settlement. And this is before we even did child support.
Your Honor, I'm going to object just in advance any reference to settlement negotiations being brought up in violation of the Michigan rules. of
I
evidence.
didn't say anything. I didn't say a specific, sir.
It doesn't matter. Settlement negotiations are neither
But
party.
that was the reason why I
denied.
denied the mediation was of just this tactics right here. So I didn't want to be told I was breaking the law and I'm a criminal and everything else. It's the tactic that I feel like is just being pushed upon me. It's either be a criminal or be made into a criminal.
Why don't you focus on the testimony you just gave? If you have anything, because a couple times in your answer, it sounded like you wanted to explain, but it wasn't appropriate at that time. So anything you want to say about what you just testified to?
During exchanges with my other child in the car, the reason why it took me longer to leave was to buckle him. And the exchange that where I exploded was after a miscommunication. I thought the parenting time ended at 8. The plaintiff told me it ended at 5. I got there at 5:30. I left immediately, and I didn't understand why they had to record. And they all got out of the car. I think her stepfather stayed in the car, but they all got out of the car to run at me. They told me they were going to call the police, and I'm like, we're meeting at a police station. I don't understand the tactic of this, to have her parents in the car every time. You want to have a calm resolution and exchange, then why bring them there? He's threatened me. He has a concealed carry weapon. He's threatened me with it. And when I went to the Walker police station, he's friends with them, so it was just pushed under the rug. So it's just, I understand the court is going to see what they see fit. And yes, I have taken it upon, and I've put a lot on your shoulders, and I'm trying to do the best that I can for myself and my children. I go to counseling. I'm really just trying to do the best. I can't make an excuse for my behavior because it was inexcusable. But that doesn't mean that I should not have rights to my children. And it doesn't mean that I should be subjugated to some made up funds to try to cover attorney fees.
Anything else?
No, ma'am. I think I don't think we need to.
All right, Mr. Swears. Any follow-up?
Nothing further, Your Honor.
All right. And Mr. Huey, I think you already indicated you did not have any other witnesses or evidence to present. You need to unmute and say yes or no.
I was pressing the unmute. Sorry, no, ma'am, I don't.
Okay. All right. Mr. Swears, closing.
Your Honor, this is fairly straightforward since we already have resolution on the court's prior order regarding custody. Really, we only have a few outstanding issues in front of the court. We would, of course, ask the court to grant the parties a judgment of divorce. We would ask the court order defendant to pay plaintiff $7,572.10 as outlined in our Exhibit A, proposed distribution of assets. And I understand this is always the hard part when we have people borrowing money from family rather than going to a bank where we have clear, unambiguous loan documents and a loan officer coming to collect. But this is not an abnormal situation. If you look at the parties' incomes, this isn't a substantial asset case, limited assets, loans from family, very normative. And for these to be, borrowed, or the idea, I think that the parties' relationship was such that Ms. Lemon, for example, was purchasing a car substantially below market or giving it to Mr. Huey free and clear immediately before a divorce was filed. I don't believe is probably the most logical inference. We would ask the court to order attorney fees pursuant to Reimer v. Johnson and to set the matter for a post-judgment motion to be submitted with the affidavits, the detailed outline pursuant to Reimer, and if an objection is filed, to hold a hearing on that matter if necessary. Again, the issue in this case that Reimer really addresses is that when you have extended litigation, there's an appropriateness to balancing the cost of litigation between the parties. Mr. Huey makes about twice what Ms. Huey made even before she had the job reduction. And a significant part of the expenses in this case are related to the ex parte motion, which the court has already seen and dealt with, but it's in the court file. There was a lot of withholding of the child. There was a lot of, frankly, just mess back December of last year that has substantially improved as a result of those orders, but it has caused plaintiff to incur substantially more fees than we normally would in a case where you don't have ex partes just trying to calm everything down. So we would ask the court to reserve pursuant to Reimer v. Johnson, or to order and requires obviously to submit affidavit, not an itemized list of fees for objection. And then most importantly, Your Honor, is really the parenting conditions in this case. There aren't a lot of assets in this case, but there is a child. And this child, the court can review the videos for itself. I appreciate Mr. Huey's willingness to acknowledge that this is not appropriate behavior in front of a 5-year-old, but the substantial concern is if, while a person is being observed at a third-party location, the reason we use these locations is it encourages people to be on their best behavior. And I think Mr. Huey's already indicated in his testimony that he feels it's appropriate to tell a 5-year-old child that his mother is dangerous, will drown him in a bathtub, that to make these sorts of threats and this sort of belligerent behavior, and we can see the effect it's having on the minor child. We're not asking the court to make any changes to the frequency of duration of parenting time, but as outlined in our trial brief, we are asking that the court impose very strict guidelines on these parenting time exchanges, that Mr. Huey remain in his car, not engage in this sort of threatening or disparaging behavior. And obviously, we would ask that the court include a very strict non-disparagement clause, because there's always a concern if this is how I talk about the child in front of the other parent when I know I'm being observed, how am I talking about the parent to the child behind closed doors? And that's obviously something that's very difficult to monitor, but we'd ask the court to impose an appropriate non-disparagement clause so that if it does become an issue in the future, the court has something to point to in an appropriate enforcement proceeding. And on that, Your Honor, we rest.
All right, thank you. Mr. Huey?
I don't believe I should have to pay the plaintiff's attorney costs. If I could afford an attorney, you think I would have gotten one, and I wouldn't have gotten treated the way I've been treated. As far as I don't talk about the plaintiff when I'm not my son. If he talks about her, he can talk about her. I don't talk about her. Once she treated my other child the way she did, she's no longer a part of my life or a part of my extracurricular. That's hearsay. That's, you can assume anybody can do anything on their own time. I mean, you could say I'm making bombs and you don't know me, you don't know nothing about me, but to insinuate that is very detrimental to somebody's character. You keep saying about how I'm a bad parent and everything else, and the plaintiff's parents have to record me every time and they have to make a big deal out of it. And you talk about it's the 5-year-old, and what about my 6-year-old that was mistreated by the plaintiff? But that's not talked about. It's a far cry for everything. And then that's my end statement. I don't believe I should have to pay her attorney fees. I believe the only thing that I'll agree to is I will pay the $500 for the Mercury because I took the car. That's the car I took. I agreed to pay that. I'm not trying to make stuff up. I'm not trying to whatever. I had no intention of being divorced and being where I'm at and barely getting to see my child and anything else. You make it sound like I planned this out. I didn't plan none of it. I would have to have planned how to make the plaintiff treat my child like garbage. I didn't plan none of that. None of that. So I appreciate your time, ma'am, and I thank you.
Right. Any rebuttal, Mr. Swears?
Only briefly, Your Honor, because the issue's been raised several times. The relying on documents previously submitted with earlier motions. I understand Mr. Huey's other child has some issues with school, some behavioral issues that the parties, all of us with small children get it. But to the extent to which there are allegations my client was mistreating the child, it's simply an overstatement of what are, I think, natural tensions in a blended family when a child not of the parties is experiencing some issues. So I wasn't really going to address it. I don't believe it's really relevant to anything in front of the court today, but just to provide the court some context, we would dispute any notion that my client is somehow mistreating. It's not really relevant now anyways, because the parties are divorcing, but just want to clarify on that point. Apart from that, nothing further, Your Honor.
All right, thank you. I will take the matter under advisement and we'll get you an opinion. I would say shortly, but I'm afraid it's not going to be shortly. I've got a couple of other cases that are ahead of you, but I will get it to you as soon as possible.
Thank
All
you, Your
right,
Honor.
thank you. We're adjourned.
Thank you.